Neama Rahmani, have you ever had a case where you feel like, you're starting maybe 10 yards deep in your own end zone with the way the judge is dealing with you?
Michael, I gotta agree with Allura here. You gotta know your audience, and this is here in LA. And I know Judge Wyndham, and he is intent on moving this trial forward. We're finally reopening here in LA County. This is one of the first jury trials that's happening. It's resuming, and it should be, because justice has been delayed for at least 20 years, maybe 40 years if you go back to Kathleen. He has made it clear time and time again. He's denied 3 motions for mistrial. The defense, you've already gone over his head. You petitioned the Second Circuit Court of Appeal here for a writ of mandate. That's not happening. So just try your case, try it on the merits, because I know you're being a good defense attorney and creating appellate issues and muddying the water, but this particular judge is not the right audience for what you're trying to do here.
Yeah, and he knows that there's appeals after trial. Deal with it there, guys. Make your record. If you're going to appeal, then you're going to appeal, and I'll deal with it. But we're not going to head that off at the pass. When the judge, and he's really spanking both of these guys, so maybe he's not leaning on one versus the other. But it sets up just a really kind of a touchy dynamic, don't you think?
Well, it does, but this is a unique case, and a unique case for many reasons. The prosecutor here, has been living with this case for years. Let's not forget, he's the one who flew out to New Orleans to personally interview Bob Durst in 2015 for 3 hours when he was arrested, right? A lot of these defense attorneys are the same folks that defended Durst in the Morris Black case and got him acquitted. So this isn't just a file that lands on your desk maybe a week ago or a month ago. They've been living with this case for years, some of them for decades. So it is very personal. And, this is a real issue when you have a case that's old, approximately 40 years, if you're talking about Kathleen Durst's death, and you have witnesses who die. I mean, it's just the reality, right? Especially with COVID. And, what we've seen in this case, and the prosecution used it, and it's a rare code of the penal code section here in California that allows for what's called a conditional examination. Obviously, the attorneys have a right and the parties have a right to cross-examine witnesses. So what they can do before trial, if they're concerned about someone's health, is to set up this examination, which is actually what John Lewin and the prosecution did for one of the key witnesses, Nick Chavin, is to examine the witness before trial. That way, if he or she passes, you can use that testimony during trial. So this is something that the defense could have availed themselves of with respect to Eddie Lopez, but they chose not to do so. So
we haven't really been advised as to the cause of death, or maybe it was sudden, don't know. So maybe they weren't able to avail themselves of the abrupt interruption of the John Lewin prosecution opening statement, second round. But nonetheless, that's what they're doing, taking a little break there. And we can tell as the camera pans to the lovely acoustic tiles of the LA County Superior Court that it is time for break. Let me tell you before we get into this and what just happened, we do have a verdict in the Zachary Wester case, guilty 17 counts of the 67. We're still sorting through it. As you know, they involve things like official misconduct and perjury and fabricating evidence and possession of a controlled substance, false imprisonment. We'll sort that out for you. Obviously, you can also go to lawandcrime.com and get a little deeper detail on that. But the bottom line is Zachary Wester, the former deputy in northern Florida there in the Panhandle, found guilty of 17 counts of the 67 against him. And again, we'll see how that all plays out in terms of possible sentences when we get a chance to pour through that. It is just breaking now out of Florida. So back to LA now. Allura Nanos with me still, and Neama Rahmani with me. Let me just start with you, Neama. Thoughts on this, at least for now, truncated opening statement by the prosecution?
Yeah, very interesting. Before we start, we see the judge stepping off the bench, addressing the jurors, basically like he is an attorney. Maybe he misses those advocacy days. And the other thing, it was just interesting to see Bob Durst there. Remember yesterday, he refused to come out, and the judge ordered LA County sheriffs to forcibly remove him and bring him to court. It's very fascinating the way Lewin started. He started by making some jokes. He's not obviously the funniest guy, but I guess he wanted to reestablish that relationship with the jurors after not talking to them for more than a year. And, he really jumped right into it, and he wants to point and portray this image of Bob Durst as a liar, because we know what he did in the Morris Black case. He's going to come up with a story. We know what the story is, and the story is, at least from the defense perspective, that he saw Susan Berman's body and he wrote the cadaver note. Well, that's not what he said, back in 2012 and 2015. So we're getting a picture of Bob Durst as a liar, and then some of the other themes that we're seeing, someone that thinks that he's above the law, doesn't have to follow the rules, and someone that had a motive to kill because she knew where the bodies were buried, at least with respect to Kathleen.
That is clearly closed captioning everything that's happening. What do you think that's about, and what do you think the impact, if any, might be on the jury?
Michael, you hit it. It's the stink, right? The prosecution wants to dirty up Robert Durst because there is going to be some sympathy. To be on these long cause cases, at least in LA County, jurors generally need to volunteer. So oftentimes you'll get jurors who are a little bit older, retirees, and now you have someone that at least looks sympathetic. He's old. He's clearly in poor health. He doesn't look like someone that would be your sort of stereotypical murderer. So there is going to be that concern for the prosecution. So they want to paint this picture and tell this story of someone that has been a murderer for 4 decades now and who's never been brought to justice, because you have this frail old man, and the concern is that some jurors might feel sorry for him.
Yeah, I think that if nobody knew about him, a little more about his background stories, you might be able to remove the stink, as it were. I'm not sure there's enough Febreze out there to truly clear the air with this guy.
And this is why this case is going to go to trial. I don't think Rivera has a good case on the merits to defend it, but he needs to preserve this issue for appeal because it's the best argument that he has to defend this case, right? The Miranda warnings were botched. I'm not saying I agree with it, but everything thereafter is fruit of the poisonous tree. So, there's the first part where it's arguably non-custodial when law enforcement, sheriff's deputies initially contact him, and he gives that consent to search his vehicle. That's where they find Tibbetts's blood and ultimately Tibbetts's DNA. So the state is going to argue that all of this was inevitable discovery. They're going down that route. This portion of the Miranda warnings, when Romero basically gave incorrect warnings, those several hours from the time that Rivera took them to the cornfield, that's already all been suppressed, so that's not an issue. Unfortunately for the state, they re-Mirandized him in the cornfield, and then those statements thereafter will be admissible.
Yeah, so we have a confession and then a recanting and then another confession. Yeah, it doesn't look good. But just to bring you up to speed there, they do have a jury in this case against Mr. Rivera. They expect opening statements first thing tomorrow morning, and of course we will be there. It's playing out like some sort of weird Shakespearean farce.
Michael, we're in Hollywood, so Lewin's going to Hollywood. I think it goes back to just him living with this case for so long. Sometimes you see it with civil attorneys that they've spent years prepping for a big fraud case or an antitrust case. It's not typical in murder trials that it's going to go on. You put on every single witness. Obviously, we got 3 murders to cover, so I understand why Lewin is doing it, but I would not proceed down this route, especially because this really has nothing to do with the defense in this case. How Dick DeGuerin and Chip Lewis are going to defend this case because they said it during their opening, and how they handled the Morris Black case in Houston. This isn't the type of case where you're going to have them just cross-examine witnesses and pound reasonable doubt during closing. This case will be about Robert Durst taking the stand, and he's going to tell a story, a very different story than the prosecution is, how he walked into his best friend's house, saw this body, panicked because like with Morris Black, he thought that law enforcement would suspect him of the murder, and that's why he admitted to writing this note. So it's going to go down that route. So I like actually what Lewin did in his opening, a little mini argument, to sort of attack those statements that the defense made in their opening. You normally don't see that because obviously the prosecution goes first. So I would focus on that, trim down these witnesses, trim down these, all this evidence. You don't need all this for the jury. Focus on rebutting their story that they're going to tell.
And when Durst takes the stand, that, my friends, is a story I want to hear. Fact or change most lives, but in context, it is important.
Yeah, it's not going to change your life when you're worth $100 million, but Michael, you nailed it. It's very rare for criminal defendants to testify, especially in murder cases, and that's what's going to happen here. So normally you have if you're the prosecution, obviously you can't comment on the defendant's failure to testify, but we know that's going to happen in this case because that's what happened in the Morris Black case. That's what happened when he was arrested and he spoke to John Lewin for the 3 hours in 2015, and he gave those 20 hours of interviews to, the producers of The Jinx. So Durst is going to come up there and he's going to say the opposite of what we normally see in these criminal trials. I have nothing to hide. and this is what his defense attorneys are going to argue. That's why I've been speaking to law enforcement and movie producers, and that's why I'm talking to you in this trial, jurors, because I am innocent. I have nothing to hide. So the defense is going to go that route, and the prosecution needs to rebut that and rebut that effectively, because we know that at least in one prior occasion, Durst was able to convince 12 jurors to acquit him.
Yeah, we keep circling back to his testifying because that is going to be what this case is about.
I'm surprised. We have a split verdict, a compromise verdict, but it's the conservative part of Florida. They love their law enforcement out there. And, I know these were the best 12 victims for the prosecution out of the more than 100, but a lot of them had drug convictions, convictions involving dishonesty, moral turpitude, and they'd filed civil lawsuits against the sheriff's department. So they got beat up a little bit on cross-examination, and I think that those 6 jurors, and again, you only need 6 out in Florida for non-capital cases, there's probably 1 or 2 that were unwilling to, return verdicts, and they required acquittals for those 9 folks.
Yeah, when you have a 6-jury member panel, if you have a stronger personality here or there, you're going to have fewer folks that can stray. So I'm a little surprised that they only got him on 17.
The video was absolutely critical in this case. Obviously, we were tracking this case. You and I were watching it on Long Crime. I'm just going through my notes right now. Obviously, Odom, guilty. We had the full video. Emmanuel, guilty with respect to him. And through my notes, he didn't activate his body cam until after he discovered the drugs, right? And the field test was negative. He told him it was positive. And then Van, looking at my notes, he didn't activate his body camera until after he began his search. So I think that's what the jury hung its hat on. They didn't want to believe the testimony of these defendants just by themselves. They really needed the video evidence, and that's why they returned the guilty verdicts for those 3 and not the others.
Yeah, they weren't buying the old, I don't know, my body cam just seems to have a mind of its own. It shuts on and comes off, yeah. and I don't know why it wasn't working at those very important moments. No, we don't see it. If we were looking at each of these charges separately without regard to the others, which is kind of like, again, bad act evidence within the same case, they separated it out and did not hold against him what they saw in the cases they did find him guilty of.
Yeah, they definitely parsed it out. You would think it would be all or nothing, especially when he took the stand and he denied it all, including Odom, saying that, he found it in the driver's side door before, he continued his search. So I would have expected them to go one way or another, either guilty on all or almost all counts, or really acquit him based on his testimony that, he found this this box of drugs and drug paraphernalia in the park. He kind of came up with this real sort of wacky story and why he didn't tell his captain and his lieutenant. But ultimately, they just really kind of went through one by one by one. And it's not only surprising that they had the split verdict, but they really acquitted on those 50 counts with respect to those 9 other victims. They didn't just hang. So maybe you had some folks there with some strong opinions.
Yeah, that's, like I said, 50 not guilty verdicts. That's amazing. So, he's a charming guy, and they were able to separate. In this particular case, the defense has done a good job of yanking some of the prosecution's case away from them. Is it going to be enough to pull off a complete defense, or just make the prosecution harder?
Probably not enough to defend the case on the merits here. You still have the blood. You still have the DNA in his vehicle. You still have the fact that he led law enforcement, sheriff's deputies, to the precise spot in the cornfield where Mollie Tibbetts' body was. And then you have that confession after the second Miranda warning. So not going to be enough. I expect a guilty verdict in this case. And really, the real legal fireworks will be on appeal when you're, trying to suppress the voluntariness of this confession, the inevitable discovery that the state is arguing, and if you're the defense, you're going to say this is all fruit of the poisonous tree.
Give me your take on the jury makeup and the area. I was talking to Anjanette earlier, and it's a very white area, not surprising. It's Iowa, and only 1 member of the 15-member jury, and that includes 3 alternates, is of apparently something other than white. What's the impact on this case where the defendant is an undocumented worker, if any?
It's a huge impact, Michael. We want to say justice is colorblind, but it's very different, this jurisdiction, this jury pool, and this particular defendant, right? This isn't, Los Angeles. This is Iowa, a very conservative state, conservative jury pool, and you have a white woman who's killed by an undocumented immigrant from Mexico. So even though we want to say that justice is colorblind, it is not, and I fully expect a guilty verdict in this case, based on the fact as well as because of the jury makeup here.
You know, it seems like such a random event. She went out jogging and apparently ran into the defendant at some point. I don't know if there is going to be a story that they had some sort of pre-existing relationship, if it was just, you know, a mugging turning into a murder. I don't know. What's your sense?
I think if you're the defense here and setting aside the confession, the Miranda, all the suppression, if you really want to defend this case, I think you have to go with the defendant's story that he basically snapped, because that's really what he told law enforcement, right? She threatens to call the police. He basically blacks out his memory, and the last thing he remembers is, you know, her headpiece, apparently, and the fact that he put her in the trunk of the vehicle. I think you got to go with that story. Try to mitigate this case, get some sort of manslaughter conviction, some lesser included. Again, I still think that's going to be a long shot, but to get an outright acquittal, it's going to be tough. Now, if he hadn't made these, you know, this confession and these admissions and these really sort of damaging statements, there were 4 other suspects that law enforcement were looking at first. So you could go in a different direction. But now that all this evidence is coming in, this really bad admission evidence, I think you got to go with mitigation.
So, you know, you're a former federal prosecutor. You've probably encountered, you know, federal law versus state law and jurisdictional issues. And here we have somebody that I guess could be deported, right? There could be federal consequences beyond his issues he's dealing with now in state court.
No question. I mean, he's looking at what we like to call a life sentence in Mexico, regardless of what happens, as an immigration detainer, and actually immigration detainer attached in this case. And that's why the non-custodial interrogation became a custodial one, and the Miranda warnings were actually required because he wasn't under arrest. But when ICE lodged that detainer, whenever someone's arrested, you know, local law enforcement that cooperates with federal authorities, they notify ICE, they put the detainer. So as soon as this case ends and he is either sentenced to prison, he's going to be looking at removal proceedings. And this is a crime of violence. Here's someone who's undocumented, but even if he wasn't undocumented, even if he was a permanent resident, a green card holder for his entire life, he came here when he was a few months old, this is a categorical aggravated felony, crime of violence, and a deportable offense. So he would be removed from the United States and barred from ever returning.
Wow. So not looking good for Mr. Rivera unless he pulls off a bit of a miracle there. Everything by the book. I'm pretty sure that's not how you would check in evidence. You just throw it in there in a Crown Royal bag and a brown crumpled up paper bag.
Mess is right, Michael, and so many things wrong with this search and this witness. First of all, I mean, he's in Florida Gator country and is wearing an Alabama Crimson Tide face covering. So, I mean, starting from there, and he's just doing the wrong thing. But he takes weeks to search the vehicle. Then when he does, his own video malfunction doesn't work in a case where we're talking about body cam not working. And then the way they handle the evidence, just basically, like you said, throwing it in the bag. And this is the case that you got to know as law enforcement. It may go to trial. You're investigating another police officer. You got to do everything right, you know, dot those I's, cross those T's, and it really wasn't done in this case. And you're just opening the door to kind of sloppy investigation and the entire argument that defense attorneys love these types of cases.
Okay, let's look at a little more of this search. Again, this was the defendant's vehicle after the fact.
Mr. Hodges, what is that black item there in your hand you're going through?
Search glove, or black glove.
And that's a different style glove than that nylon glove you have on there, correct?
That's correct.
Or I say nylon, maybe it's latex.
Latex.
Yeah, latex glove, correct?
Correct.
The Alabama face gear that the guy was wearing. I really hadn't noticed that the first time. I don't know if that was a good selection or not. Anyway, if you could recall your thought, you want to repeat it, feel free to finish that up.
Yeah, you know, the seizure, right? This huge box, you know, and again, Wester always has an explanation, right? Whether it's the baggie floating away, you know, and it's prosecuted cases, and I've actually had defendants argue the opposite, that the drugs somehow blew into my car, or counterfeit money blew into my car. So it's interesting to see law enforcement argue the opposite, that it blew away. But he has to have an explanation for this box, right? And regardless of sort of the sloppiness of the search and the seizure there, and for him to argue that, you know, he found this in a park, and, you know, he didn't tell his captain, he didn't tell his lieutenant, even though it would have been the biggest bust or drug seizure of his career. It really kind of defies all logic and credibility. But ultimately, I don't think the jury made a whole lot of it, and they really kind of based it on that body cam footage, as we discussed. But he seemed to have an answer for everything.
Yeah, and I wonder if there really was a bust. You know, did he just accumulate this from other smaller busts, or who knows, from the evidence lockers? You know, maybe that big bust was just a way to cover the fact that this guy's got a lot of junk in his trunk there. So, okay, one quick question before we wrap things up here. Sentencing is going to be a mess. I haven't gone through all the different charges. We know that even if he'd been hit with everything, 67 charges, 20 years likely, probably 12 or 13 sentenced, less out in 8. Give me your best guess. How much time is this guy really going to do?
I mean, hopefully the judge throws the book at him, you know, and imposes the trial tax, because here's someone who, you know, under the Florida merger doctrine, you know, he's not going to look at obviously that 20-year max under the guidelines, but here's someone who violated the public trust, right? And it's more than the 100 or so people who were affected and all these charges that were dismissed. I mean, this is the type of law enforcement officer that causes people to distrust law enforcement. It wreaks havoc in our criminal justice system. I can't tell you how many times I've prosecuted folks who said, you know, hey, they planted the drugs in my car, I had no idea, or it wasn't me.
And it's, you know, there is certain maybe broader satisfaction that this guy's going to go down to some degree. Hey, Neama Rahmani, thank you so much. Appreciate it. Former federal prosecutor. Join me again next time. Good to see you.